Okay, so it's time to talk about the disciplinary process. In other words, the way in which matters involving a breach of the standards, the ethical rules, the uniform law, get brought in front of a tribunal. So essentially, ultimately VCAT, so that a decision is made. So before we do that, let's actually just think about why it is that we have professional disciplinary regimes. This is discussed in Del Pont in some detail in chapter 23. And ultimately, there are multiple purposes for having a professional disciplinary regime. To remove those who are not fit and proper persons so that they no longer practice in the profession, and as a consequence we then protect the public against them. And as I mentioned in the introduction video, then disciplinary proceedings are not criminal proceedings, so punishment isn't the principal aim, but it might actually be a byproduct of that protection. Secondly, to deter other lawyers from similar misconduct and to maintain the reputation of the legal profession. So when I was talking in the introduction about the idea of a self-regulating body and the profession regulating itself, part of the genesis of that idea was this idea that we as a group need to find a way to cohesively work together so the bad deeds of one of us don't bring the rest of us down, because we need to maintain a high standard in the eyes of the public. Of course, there are going to be issues with focusing too much on professional discipline on the basis that it maintains the quality or the prestige of the profession. Of course, there might be other potentially more effective methods of protecting the public. In fact, one of the things that we've seen with the advent of more and more technologies is that we're seeing legal process being able to be delivered more efficiently and effectively, particularly when there's a repeatable process involved, or when we can train AI to really look for that smoking gun in the haystack. If I can mix my metaphors anymore, I will. But by maintaining this kind of idea of like a limitation to the profession and stopping others from practicing law unless they're a member of our club, unless they hold their practicing certificate, maybe we're not protecting the public. Maybe there are other ways of doing that. Another issue that comes up from time to time is an unreasonable perception from the public generally about what a lawyer should or should not be able to do. One of the things I bet you've noticed already, that you go to a party or a pub or something and you tell somebody you're studying law, and they start to treat you slightly differently. They probably think you're smarter than they thought you were before. That happens a lot. But also, particularly once you are actually admitted, they'll start to ask you all sorts of questions. The one I used to get all the time was, how loud can my neighbour have their music going after 11 p.m. at night? Like, what do I know? I'm an M&A and a technology lawyer. I've got no idea about the rules for fencing or torts or any of that stuff, really. I mean, I only know what I needed to know to get through it at law school. There's this unreasonable expectation that we have of all sorts of professionals, whether it's lawyers, doctors, engineers, that they will know all of these things and be able to do all of these things. And they may not be able to meet those standards all the time. Another thing you might want to think about is disciplinary proceedings are publicly funded and they're expensive. Of course, there are opportunities for some of the costs to be recovered, but we need to think about whether or not that's the right approach. And Del Pont talks about that in chapter 23. And another thing to think about is the whole process. We can think that if somebody hasn't been through the disciplinary process, that they're paragons of virtue. I think of this as the working with children equivalent. Like a working with children check doesn't mean that you are going to be a good babysitter or that you are going to be able to protect children at all costs. It just means that you haven't been found, or the records don't show that you've ever been caught or accused of any offence involving children. So it doesn't mean that you're a good child, a good babysitter. Similarly, the fact that you haven't been hauled in front of a disciplinary committee doesn't mean that you're a good lawyer. And so we should be thinking about these purposes, and we should be thinking about whether they're justified as we work through them. The slide that I have in front of you here is an attempt to kind of summarize what the process looks like. So I've got a range of different institutions that are relevant here. So some of them are basically belong to the profession. So the Law Institute of Victoria, I've been plugging membership for it since you began. Student membership is free and really helpful. But it's basically, it's a professional body. You can join if you are a lawyer or if you are a law student. And it's effectively our union, for want of a better name for it. It's a professional association that represents the profession. It takes delegations from the board, so the Legal Practice Board, for making legal profession rules, to investigate claims against fidelity funds, trust accounts, and other investigations. And it can deal with complaints about the legal profession, professional misconduct, and civil disputes under a $10,000 limit. Similarly, the Victorian Bar Council will take delegations from the Legal Practice Board for making legal professional rules in relation to barristers. So the Legal Services Board, now you'll go and have a look at the website, you'll see it's the Legal Services Board and the Legal Services Commissioner. They share a website, they're basically one entity, but it has separate functions. And the Legal Services Commissioner and the Legal Services Board, we need to think about them as separate sets of roles. So the Legal Services Board will refer matters to the Commissioner, who happens to also be the CEO of the Legal Services Board, who, if the Legal Services Commissioner determines under the rules that there's been professional misconduct, it will refer those matters on to VCAT. The Legal Services Board can also refer civil disputes, so of amounts greater than $25,000 that it is unable to resolve. So yeah, kind of a quick and dirty kind of moving down the chain, what happens next. So think of this not as a hierarchy, but more as a timeline. So where matters start and where they end up at the bottom of the timeline. Chapter 5 of the Uniform Law is really where you need to go to start when you're thinking about disciplinary proceedings. It sets out the dispute resolution and professional discipline regime. Section 265 of the Uniform Law provides that a complaint in relation to a lawyer or a law practice, this is interesting because the common law really looks at lawyers rather than law practices. The Uniform Law expands to law practices as well. So a complaint may relate to any dispute or issue about conduct to which Chapter 5 applies. So when defining a complaint, when looking at disciplinary matters, the question goes back to whether or not there is a complaint. So section 265 and 268 at the beginning of Chapter 5 of the Uniform Law are absolutely key here. Section 2681 provides that a complaint may be either or both a consumer matter or a disciplinary matter. So it can be a consumer matter, a disciplinary matter, or it can be a consumer matter and a disciplinary matter. Section 2682 provides that a dispute or issue about conduct that is the subject of a complaint can be both a consumer matter and a disciplinary matter, and indicates by way of example that a cost dispute or an issue relating to costs can be both a consumer and a disciplinary matter. So again, we've got these overlapping definitions. We've got consumer matters, we've got disciplinary matters, and we've got matters that are both. So how and why does this matter? Doesn't surprise you. I have a slide to try and explain this. So 269 is the relevant provision here. 269 269 and 270 of the Uniform Law. So in 269(1), we get a definition of a consumer matter as being that part of a complaint, effectively, about a lawyer or a law practice that relates to the provision of legal services to the person who's making the complaint by the lawyer or the law practice, and which the designated local regulatory authority, so in the case of Victoria, that's the Legal Practice Board, determines should be resolved by the exercise of functions relating to consumer matters. In other words, it's that part of a complaint that a member of the public makes that really goes to professional conduct, which may be resolved as really the consumer maybe not understanding the process, or which might relate to a dispute over the bill, which doesn't go to gross overcharging. So this kind of arguably distinguishes matter from disciplinary matters, which are described in a bit more detail in section 710. So, but before I get there, not 710, 270, sorry about that. A consumer matter also could be a cost matter. So that's a cost matter is a dispute about legal costs payable on a solicitor-client basis, where the dispute is between a lawyer or a law practice and a person who is charged with those legal costs. So in other words, their client, or is liable to pay those legal costs. So a third-party payer. We talked about those a couple of weeks ago. Whether as a client of the lawyer or as a third-party payer. Section 270, on the other hand, defines the disciplinary matter as being that part of a complaint about a lawyer or a law practice as would, if the conduct concerned has been proven, amount to unsatisfactory professional conduct or professional misconduct. So a consumer matter might be an allegation of professional misconduct, might involve costs, but is something that the Legal Practice Board can deal with. It's not amounting to something that the profession itself would call professional misconduct or unsatisfactory professional conduct. On the other hand, a disciplinary matter is something where it can't just be resolved as a dispute between the client and the lawyer, or the third-party payer and the lawyer. It goes to the conduct of the lawyer being professional misconduct or unsatisfactory professional conduct. And so a declaration relating to professional conduct, unsatisfactory or misconduct, needs to come from the tribunal and is a disciplinary matter. The role of the Legal Services Commissioner is to oversee the implementation of the dispute resolution and professional discipline elements of the legal profession uniform law. Now, that's been running for a little while now, and so the board deals with the consumer matters, the Commissioner deals with the disciplinary matter. The Legal Services Board is not a disciplinary body, but it does have some responsibility for making rules under the uniform law and monitoring its implementation. So before we get any further along, we probably need to stop for a second and think about the ways in which complaints are handled. It probably won't surprise you to know that many complaints relate to costs. And by far the greatest number of complaints or hearings that are published relate to dissatisfaction with costs in some way. Now, not all complaints that are made against lawyers are justified. Complainants may have failed to specify the nature of their complaint. They may have failed to understand what was actually required of the lawyer or even of themselves, or they may just simply be disappointed at the outcome of the proceedings, despite their lawyer doing the best job that they can do. In some cases, particularly in very emotional matters involving family law, wills, disputes with family members, divorces, and also some criminal matters, people get very upset. Some clients are vindictive, but all complaints need to be investigated. And even if some of them can be dismissed really, really early on. When complaints are accepted, the investigating authority notifies the lawyer that a complaint has been made and requests a response from them. If a lawyer fails to respond to a complaint, no matter how ill-founded or unjustified the complaint might be, or if they fail to attend a mediation or to obey the direction or orders of the investigating body, or to respond to notices from that body during the investigation process, that kind of conduct itself can constitute professional misconduct. So no matter how unjustified or ill-conceived a complaint against you might appear to be, you need to take it seriously and respond to it properly. Complaints are generally required to be in writing or recorded in writing, and they need to name both the complainant and the lawyer or the law practice that is the subject of the complaint. The aim of the uniform law is to achieve consistent approaches to dealing with complaints. One of the criticisms of self-regulations is it's a club, and that we treat members of our club differently depending on how much we like them, essentially. The delegated regulatory authority, so the Legal Services Commissioner, is not required to take action to resolve consumer matters unless it is of the opinion that at least one of the parties has made a reasonable attempt to resolve the matter and has not been successful at doing so, or that it wouldn't be reasonable to expect the complainant to be involved in that kind of attempt. Have a look at section 286. And failure to cooperate reasonably in the disciplinary process can result in harsher findings, but even so, we need to remember that natural justice will apply, or the rules of natural justice will apply. Take a look at Del Pont, chapter 23. Complaints have time limits. There's a time limit for bringing the complaints, and in relation to matters other than cost disputes, the uniform law sets out a time limit of 3 years from the matter giving rise to the complaint, but gives some discretion to the relevant authority to waive that time period if the relevant authority, so the Legal Services Commissioner, is satisfied that it is just and fair to deal with the complaint, having regard to the delay and the reasons that it occurred, or where the complaint involves an allegation of professional misconduct and it's in the public's interest to deal with the complaint. And there are similar time limits in other jurisdictions, just in case you're interested. The slide, you probably won't be able to read it on a YouTube on your phone, but the language from section 272 is set out there in full, and it would be, with my emphasis, but it would be useful for you to make sure that you're aware of that section and what it means. I mentioned, I was going to come back to this before, that traditionally the focus when we talk about complaints, at common law in particular, has been on the lawyer, not on the law practice. But it's really important to remember that that under the uniform law, disciplinary matters can be brought against a law practice as well as individual lawyers. Disciplinary matters concern conduct, so that the history in the common law has looked at disreputable actions of lawyers as individuals. Non-disciplinary, so non-cost related complaints, at this stage, I don't think that there have been any that have been lodged against a law firm, that they've been lodged against the individual practitioners. But that is something that I should double check and will double check before I finish this set of videos, and I'll make sure that the answer is clear. Take a look at part 5.4 of the Uniform Law to really make sure that we're clear on what the disciplinary process involves. In the next video, I'm going to talk a little bit about investigation